If we truly want world peace, then we have to end immoral trafficking, because immoral trafficking is a dangerous and violent business. Hello everyone, welcome to UN College digital class. Now you are watching video lecture on Immoral Trafficking Act. We had already discussed about Dowry Prohibition Act, Domestic Violence Act of Social Legislation for Women, and now we are continuing Immoral Trafficking Act 1956, and we already discussed from section 1 to section 16 of Immoral Trafficking Act. So go through it to know about the sections which we had already discussed, and in this class we will discuss from section 17 of Immoral Trafficking Act. Under section 17 of Immoral Trafficking Act, there is intermediate custody of persons removed under section 15 or rescued under section 16. Custody of the person who are removed under section 15 through search without any warrant and rescued under section 16. So we will discuss on section 15 and section 16 services under this act, and in this act all the sections are interlinked and all the sections are interdependent upon other sections. Subsection 1 of section 17, when the special police officer removing a person under subsection 4 of section 15 or a police officer rescuing a person under subsection 1 of section 16 is for any reason unable to produce him before the appropriate magistrate as required by subsection 5 of section 15, or before the magistrate issuing the order under subsection 2 of section 16, he shall forthwith produce him before the nearest magistrate of any class, who shall pass such orders as he deems proper for his safe custody until he is produced before the appropriate magistrate, or as the case may be, the magistrate issuing the order. And the section 17 subsection 1 provided that no person shall be, when a person removed under section 15 and rescued under section 16, the magistrate give order of custody of the person, because if the person will run away, then the magistrate will face problem to dismiss that case. So the magistrate always order for safe custody of the person who is removed or rescued under section 15 or under section 16. But I detained in custody under this subsection for a period exceeding 10 days from the date of the order under this subsection. When the magistrate order for detained in custody under this section, that period being for 10 days from the order date, then restored to or placed in the custody of a person who may exercise a harmful influence over him. Who exercised any harmful influence, then there is need of custody of that person who is committing any harmful influence for others, and other persons are facing problem for a person which is harmful for their life. Then subsection 2 of section 17, when the person is produced before the appropriate magistrate under subsection 5 of section 15 or the magistrate under subsection 2 of section 16, he shall, after giving him an opportunity of being heard, cause an inquiry to be made as to the correctness of the information received under subsection 1 of section 16, the age, character and antecedents of the person and the suitability of his parents, guardian or husband for taking charge of him, and the nature of the influence which the conditions in his home are likely to have on him if he is sent home, and for this purpose he may direct a probation officer appointed under the Probation of Offenders Act 1958, 20 of 1958, to inquire into the above circumstances and into the personality of the person and the prospects of his rehabilitation. There is inquiry of correctness of a person when the person produced for custody to his family or parents or any guardian of his family, then there is need of inquiry or investigation of that person, because to know about the person or to know about the changes in characteristics, the changes in nature and behavior of that person, because when the family or parents taking charge of that person, then they have to discuss about that custody with the probation officer who is appointed under Probation of Offenders Act 1958 for rehabilitation of that person. Subsection 3, the magistrate may, while an inquiry is made into a case under subsection 2, pass such orders as he deems proper for the safe custody of the person, which is provided that where a person rescued under section 16 is a child or minor, it shall be open to the magistrate to place such child or minor in any institution established or recognized under any Children Act for the time being in force in any state for the safe custody of children. Provided further that no person shall be kept in custody for the purpose for a period exceeding 3 weeks from the date of such an order, and no person shall be kept in the custody of a person likely to have a harmful influence over him. Magistrate inquired a case to know about proper safe custody of the person. If where person is rescued from sexual exploitation and if the person is child or minor who is completed 16 years and not completed 18 years, the magistrate has to place that children in custody of any institution which is registration under state government and also registration under Children Act, because which institution will provide facilities to the children. Institution has to registered under Children Act, because under Children Act the institution can provide the provisions and provide basic needs of a child for survive their life in a society. Subsection 4, where the magistrate is satisfied after making an inquiry as required under subsection 2. When the magistrate inquired any requirement under subsection 2, then the magistrate is satisfied for A, that the information received is correct. For the information magistrate collected, magistrate inquired that the informations are correct or wrong, and the person who are involved in that case are facing problem for wrong information. So, the magistrate has to need of right information or correct information, so that they have to inquire, they have to investigation on that information to know about details of the information. Part B, that he is in need of care and protection, he may, subject to the provisions of subsection 5, make an order that such person be detained for such period being not less than 1 year and not more than 3 years, as may be specified in the order, in a protective home or in such other custody as he shall for reasons to be recorded in writing consider suitable provisions. When the person has need of care and protection, then the person get the facility of protective homes and also corrective institutions to correct himself or to change himself as a better person, as a good personality. And also in protective home, the provisions of education and different developmental provisions provided to that person. And in protective home also providing proper care, guardianship, education and psychiatric treatment for mental condition or for mental illness. If the person facing any mental illness or anxiety or any other issue which is related to psychiatric problem, then the person has to need of psychiatric treatment. So, in protective home there is the provisions of psychiatric treatment for that person who has need of psychiatric treatment. And under this subsection part B of subsection 4, it provided that such custody shall not be that of a person or body of persons of a religious persuasion different from that of the person, and that those entrusted with the custody of the person, including the person in charge of a protective home, may be required to enter into a bond which may, where necessary and feasible, contain undertakings based on directions relating to the proper care, guardianship, education, training and medical and psychiatric treatment of the person, as well as supervision by a person appointed by the court, which will be enforced for a period not exceeding 3 years. And with all the facilities like guardianship, education, training and medical and psychiatric treatment also, there is supervision of a person for to know about that person, to know about characters, to know about behaviors and manners of that person. Because of inquiry, the magistrate can know about the changes of that person who is removed or rescued under section 15 or section 16. Then subsection 5, in discharging his functions under subsection 2, a magistrate may summon a panel of 5 respectable persons, 3 of whom shall wherever practicable be women to assist him, and may for this purpose keep a list of experienced social welfare workers, particularly women social welfare workers in the field of suppression of immoral traffic in persons. Under subsection 2, the magistrate order a team of 5 members, including at least 3 members of that team as women, and the women members belongs from any welfare institutions, or the women members can be a social welfare workers belongs from any social welfare institution which is recognized or registered under state government under any act, to assist the magistrate or to assist him and cooperate him to deal with immoral trafficking issue of our society. Subsection 6, an appeal against an order made under subsection 4 shall lie to the court of session whose decision on such appeal shall be final. Under subsection 4, an order of magistrate shall be final. When the magistrate ordered anything, ordered any notice, then that notice or that order will be final. No one can fail or no one can deny the order of the magistrate. So, these orders are final which is made by the magistrate. Section 17A, conditions to be observed before placing persons rescued under section 16 to parents or guardians, notwithstanding anything contained in subsection 2 of section 17, the magistrate making an inquiry under section 17 may, before passing an order for handing over any person rescued under section 16 to the parents, guardian or husband, satisfy himself about the capacity or genuineness of the parents, guardian or husband to keep such person by causing an investigation to be made by a recognized welfare institution or organization. When the person rescued by special police officer or any trafficking police officer whose duty is dealing with immoral trafficking issue, and they have to investigate, they have to inquiry of such person who are involved in prostitution or who are involved in immoral trafficking issue, and also investigate on such person who are removed or rescued under section 15 and section 16 and being on custody of parents or guardians or husbands of that person. Before produce the person to the family or to the parents, then the magistrate has to investigate about the person through the help of any welfare institutions of the society, which institutions are working for welfare of our society or for development of our society. Then section 18. Under section 18, there is closure of brothel and eviction of offenders from the premises. This section defines that the act of forcing someone to live somewhere, especially their home or any premises. Subsection 1, a magistrate may, on receipt of information from the police or otherwise, that any house, room, place or any person thereof within a distance of 200 meters of any public place referred to in subsection 1 of section 7 is being run or used as a brothel by any person or is being used by prostitutes for carrying on their trade, issue notice on the owner, lessor or landlord of such house, room, place or person of the agent of the owner, lessor or landlord or on the tenant, lessee, occupier of or any other person in charge of such house, room, place or person to so cause within 7 days of the receipt of the notice, for the same should not be attached for improper user thereof. And if after hearing the person concerned, the magistrate is satisfied that the house, room, place or person is being used as a brothel or for carrying on prostitution, then the magistrate may pass some orders. If magistrate get any information about any premises which premises are using for sexual exploitation services provided to the customers in commercial purpose or in trade purpose, that area should be prohibited. And if that area is under 200 meter distance from any public place, for example, any educational institution, any hospital, medical or hostels or any religious institutions also, then that area or that premises should be prohibited for prostitution services or for sexual exploited services for the customers. And if the magistrate feels satisfied or if the magistrate investigate that the area can be used for brothel, then the magistrate will provide an order. Part A of that order, which is provided the magistrate, is directing eviction of the occupier within 7 days of the passing of the order from the house, room, place or person. When the magistrate order for leave the place where prostitution services is going on, leave that place within 7 days, they have to leave any house, room or any person which was using for sexual services. Then part B, directing that before letting it out during the period of 1 year or in a case where a child or minor has been found in such house, room, place or person during a search under section 15 during the period of 3 years immediately after the passing of the order, the owner, lessor or landlord or the agent of the owner, lessor or landlord shall obtain the previous approval of the magistrate, which is provided that if the magistrate finds that the owner, lessor or landlord as well as the agent of the owner or any landlord was innocent of the improper user of the house, room, place or any portion of that area, he may cause the same to be restored to the owner or landlord or the agent of the owner with a direction that the house, room, place or person shall not be leased out or otherwise given possession of to or for the benefit of the person who was allowing the improper user therein. The person who are using of any houses, any room or any portion of any area, that area should be leased out because of prohibition of immoral trafficking issue. Then subsection 2, a court convicting a person of any offence under section 1 without further notice to such person to show cause as required in that subsection. Under subsection 1, there is facilities for them when a court convict any person is committing any offence, then there is a punishment for that person under subsection 3 or section 7, which is ordered by the magistrate. Then subsection 3, orders passed by the magistrate or court under subsection 1 or subsection 2 shall not be subject to appeal and shall not be stayed or set aside by the order of any court, civil or criminal, and the said orders shall cease to have validity after the expiry of 1 year or 3 years, as the case may be. It provided that where a conviction under section 3 or section 7 is set aside an appeal on the ground that such area or such premises or any portion of that area is not being run or used as a brothel or is not being used by prostitutes for carrying on their trade, any order passed by the trial court under subsection 1 shall also be set aside. Then subsection 4, notwithstanding anything contained in any other law for the time being in force, when a magistrate passes an order under subsection 1 or a court passes an order under subsection 2, any lease or agreement under which the house, room, place or person is occupied at the time shall become void and inoperative. And under subsection 2, the magistrate ordered that under subsection 1 and subsection 2, the area or house or room or any premises which are using for prostitution services shall be void, it shall be prohibited. Then subsection 5, when an owner, lessor or landlord or the agent of such owner, lessor or landlord fails to comply with a direction given under clause B of subsection 1, he shall be punishable with fine which may extend to 500 rupees, or when he fails to comply with a direction under the provision to that subsection, he shall be deemed to have committed an offence under clause B of subsection 2 of section 3 or clause C of subsection 2 of section 7, as the case may be, and punished accordingly. When the owner or landlord or any housekeeper of such owner fails to follow the order of magistrate, then he shall be punishable under this section with fine which may extend to 500 rupees, and under this section punished accordingly. There is punishment for that persons who are offenders, or the offender can be a landlord, can be a tenant, or can be a housekeeper who is keeping charge of any area and using that area in prostitution services or in sexual services, and provided that services to the customers in purpose of trade or business. Then section 19, application for being kept in a protective home or provided care and protection by court. Under section 19, the court provided protective home. Under protective home, the person get care and protection if there is any need of that. Subsection 1 of section 19, a person who is carrying on or is being made to carry on prostitution may make an application to the magistrate within the local limits of whose jurisdiction. When a person is carrying prostitution or carrying sexual services, then the magistrate has local limits on that activities. The magistrate an order, that order may be in a protective home. A person should kept in a protective home for care and protection, because in protective home the persons who are working in protective home, they are providing protection and providing guidance and providing facilities how a person can change himself, can change his character and can change his behavior and manner, through which a person will be a good person from a offender. So, there is care and protection in protective home for a person if there is any need for that person. And part B, provided care and protection by the court in the manner specified in subsection 3, which we already discussed under subsection 3. There is different facilities provided to the person who is staying in protective home. Then subsection 2, the magistrate may, pending inquiry under subsection 3, direct that the person be kept in such custody as he may consider proper, having regard to the circumstances of the case. When the person kept in custody, then the magistrate has to inquiry to know about the case in detail. When the person kept in custody or kept in any protective home or corrective institution, then the magistrate investigate or inquiry on that person to know about his person, to know about the person's activity, the person's nature and the person's details, through which the magistrate can order for custody. Subsection 3, if the magistrate, after hearing the applicant and making such inquiry as he may consider necessary, including an inquiry by a probation officer appointed under the Probation of Offenders Act 1958, 20 of 1958, into the personality, conditions of home and prospects of rehabilitation of the applicant, is satisfied that an order should be made under this section, he shall, for reasons to be recorded, make an order that the applicant be kept. When the applicant apply for any service, the magistrate shall inquiry on that for a necessary need of the person, and also inquiry from probation officer who is appointed under Probation of Offenders Act 1958, because from inquiry the magistrate can know details about the person, can know details information about the person, through which the magistrate can decide, can order for the custody or for providing any protective home or corrective institution to that person. There is any necessary or not necessary for that person. The applicant should be kept in, first one is in a protective home. A applicant can be kept in a protective home for proper care and protection, which will provide them safe and secure life. Then 2, in a corrective institution. The applicant can kept in corrective institution to correct themselves, to correct their character or to change themselves. Then under the supervision of a person appointed by the magistrate, and the magistrate supervise that person. When the person kept in any protective home or any corrective institution, then the magistrate supervise the person's activity and supervise details of the person for such period as may be specified in the order. A person can be kept in a protective home or in a corrective institution or under supervise of the magistrate, but the time has limitation. The time ordered by the magistrate for 1 year or for 3 weeks, different facilities for the person who is kept in any protective home or corrective institution, there is a time limit which is ordered by the magistrate. Then section 20, removal of prostitute from any place. Eradication of prostitution issue from our society. Section 20 provide different provisions for removing of prostitution. Subsection 1, under section 20, a magistrate on receiving information that any person residing in or frequenting any place within the local limits of his jurisdiction is a prostitute may record the substance of the information received and issue a notice to such person requiring him to appear before the magistrate and so cause why he should not be required to remove himself from the place and be prohibited from re-entering it. When the magistrate receiving any information about any premises which is using for sexual services and with leading by some persons, the magistrate forwarded a notice to such person to stop prostitute service from that place and prohibit that area the entering of people to that place for next time. Every notice issued under subsection 1 shall be accompanied by a copy of the record aforesaid, and the copy shall be served along with the notice on the person against whom the notice is issued. Under subsection 1, when the notice issued against the person and there is need of a copy which is provided to the person, that person is against whom the notice is provided. So, the magistrate has to provide a copy of that notice to such person. Under subsection 3, the magistrate shall, after the service of the notice referred to in subsection 2, proceed to inquire into the truth of the information received, and after giving the person an opportunity of adducing evidence, take such further evidence as he thinks fit, and if upon such inquiry it appears to him that such person is a prostitute and that it is necessary in the interest of the general public that such person should be required to remove himself therefrom and be prohibited from re-entering the same, the magistrate shall by order in writing communicated to the person in the manner specified therein, require him after a date to be specified in the order, which shall not be less than 7 days from the date of the order, to remove himself from the place to such place whether within or without the local limits of his jurisdiction, by such route or routes and within such time as may be specified in the order, and also prohibit him from re-entering the place without the permission in writing of the magistrate having jurisdiction over such place. It is clear in this subsection 3 of section 20, the magistrate properly inquiry of every person, and when got to know that person involving in prostitution, then the magistrate prohibit that person to involving in prostitution service or in sexual exploitation services, and prohibit the person to re-enter to that premises or to re-enter that activity or re-enter to the prostitution services. Then subsection 4, whoever but A fails to comply with an order issued under this section within the period specified therein, or whilst an order prohibiting him from re-entering a place without permission is in force, re-enters the place without such permission. When the magistrate fails to comply with an order which is issued under this section, there is prohibition of re-enter a place without permission of the magistrate. Then part B, knowing that any person has under this section been required to remove himself from the place and has not obtained the requisite permission to re-enter it, conceals such person in the place, shall be punishable with fine which may extend to 200 rupees, and in the case of a continuing offence with an additional fine fees may extend to 20 rupees for every day after the first during which he has persisted in the offence. A person who is involved in prostitution services, the person has to remove himself from that premises and don't re-enter that place. If that offence will commit, then the person will be punishable under this section with fine of 200 rupees. If that case continuing or if that issue continuing and the person re-enter to that place or person involving in prostitution services, then the person should be give fine of 20 rupees per day from the day of offence. On which date the offence started, from that date the person has to pay 20 rupees per day for any offence which is related to prostitution or sexual service. Here we have discussed from section 17 to section 20 of Immoral Trafficking Act 1956, which will help us to aware about different sections, different provisions which is provided under Immoral Trafficking Act for them who are facing problem in our society. So, keep watching. Thank you.